if the order of the magistrate court was procedurally flawed and legally baseless, then why is it that the Sessions Court has refused to give Mr. Rahul Gandhi any kind of relief? Swaty ji.
Well, whatever the Session Court has said today in its order, that is also completely flawed, and it's filled with loopholes. It's filled with factually incorrect things, legally you can't uphold those things legally, though the reasoning that has been given by the Session Court. And that is why, like you said, right now, we will be moving the High Court. There are times when, the lower courts do not pass the correct orders in the opinion of the litigant. And that is why the High Court and the appellate courts are open to us. So that is why we will be approaching the High Court tomorrow or day after. And I can get into the grounds of appeal right now. They're going to be added. There are going to be a lot more grounds than what we'll discuss on the debate. And I can talk about the loopholes of the debate of the order as well. But as and when you want to start the debate on the loopholes of the debate, I'm happy to loopholes of the order. I'm happy to do it.
Touch upon the political aspects of this debate as well. The BJP has been making that argument, and Sanju, I'll just come to you. The BJP has been making that argument that the Congress party or certain individuals, clearly hinting towards Rahul Gandhi, consider themselves to be above law. They say that they are the judge, jury, and the decisive force in this country, and if they've said a court order is flawed, then it is flawed. That's their argument. Is that an argument with any degree of substance?
Absolutely not. Absolutely not. Rahul Gandhi, when he was summoned by the court, he went, he attended his hearing, he attended the court, he gave a statement. If he thought himself to be above law, or if the Congress party thought that he is above law, the Congress party is above law, then we would not abide with any court order. And not just this order. After this, when the disqualification happened, he's been asked to vacate the house. The vacation has already started. Right? He's already started the procedure of vacating the house as well. So where is this whole, this high-handedness is not what the Congress or the Gandhi family has. It is what the BJP is suffering with. It is, and you
Sanju
can see
where is the high-handedness? Rahul Gandhi has responded to the court summons. He has complied with the court order. He has vacated his bungalow. Then why are you making this to be some kind of, an instance where Mr. Gandhi has not complied with any kind of orders? Congress party says he is a law-abiding citizen. We will move the court of law. Sanju ji.
Thank you, Anusha. Good to be on your show after quite a bit. Anusha, let me just make a couple of points, though you summed up in the introduction very succinctly, but for the benefit of your viewers, there are certain things I want to reinforce. Point number one, the additional sessions judge, Justice Robin Mogera, clearly said that the trial of Rahul Gandhi and the subsequent judgment is fair and not harsh. Rahul Gandhi and his lawyers were given sufficient time to cross-examine the witnesses from the other side. Point number two, the judge clearly said that Rahul Gandhi did not only humiliate the Prime Minister but caused mental agony to many people within the OBC community who have Modi as the surname. The third and I think very important argument made by the judges that Rahul Gandhi and his counsel failed to prove that disqualification basically means an irrevocable loss. The judge clearly said that disqualification does not tantamount to an irrevocable loss, and Rahul Gandhi has not been able to showcase how this is an exceptional circumstance or the rarest of the rare cases whereby his conviction should be stayed. And I think the other important thing, because the Congress brass has been quoting Section 389(1) of the CRPC, saying that Section 389(1) has been abused and misused. So I would like to remind the Congress, legal brass that Justice Robin Mogera also said that any judgment given by using Section 389(1) of the CRPC is discretionary and is completely within the bounds of the said judge, how or he or she wants to use Section 389. And I think we need to also note one very important thing. Be it the Lily Thomas judgment of 2013, be it the Lok Prahari judgment of 2018, or Anusha for that matter, be it the Ravikant S. Patil judgment of 2007. And I will just take 10 seconds to tell you that in the Ravikant S. Patil judgment of 2007, the execution of the sentence was stayed, but the conviction per se was not stayed, by virtue of which the disqualification was not stayed. So I think Rahul Gandhi can argue till the cows come home, but if you look at past history of Supreme Court verdicts in this particular matter pertaining to criminal defamation and disqualification. Nothing out of the ordinary has been done. 37 MLAs and MPs in the past many years have been disqualified when they have been convicted, including 7 from the BJP. Let's not forget Lalu Prasad Yadav, ex-chief minister, was disqualified. J. Jayalalitha, ex-chief minister, was disqualified. Rashid Masood, a Congress MP, was disqualified
Sanju Verma,
in 2013.
I think it's a settled proposition of law, and it's a law laid down by the Supreme Court of India, that if you're convicted and your sentence is more than 2 years or 2 years, then you are barred from contesting elections. That's the law of the land, and it's same for all individuals, whether in the Congress or in the BJP. Swaty, I'm coming back to you. And, this entire argument that the Congress party has also been earlier raising about institutions being hijacked and not doing their job. There is a rather provocative question which is often put to the Congress party, that do you have no faith in the institutions of this country? So when you say that a magistrate court order was procedurally completely wrong, or Sessions Court today has not granted you relief and they have not understood the law, are the courts correct only when they agree with the Congress party?
Sure, thank you for asking this question, because there seems to be a lot of confusion about, criticism of judgment taken to be criticism of the court.
Yeah.
If we were not to criticize the judgment passed by the court, there would be no appeals filed by anybody. There would be no appellate courts. It is only when we criticize a judgment, an opinion, a judgment by the court that we file an appeal. So the fact that the Constitution provides us with an option, right, where if we can criticize the judgment and file an appeal, then there is no question of criticizing courts. That can't be taken, that can't be equated with criticizing courts. Coming back to this order that has been passed today, we are not criticizing
one point that I want you to perhaps clarify. There's an interjection. When you say that a complete due process at a magistrate court was vitiated and was illegal and was somewhere politically influenced, that's not a criticism of a particular order or a judgment. It's a statement on the institution which you're authorized to make in a functioning democracy. But at least own up to it, that's a comment that you're making on a particular institution.
Well, you look at the timeline of that case, and we are not pointing fingers at a particular judge who's passed this order. No, it is not that. But if you look at the timeline, there are sometimes even in the judiciary, there's some sort of procedural things which are used and misused by all of us, by the litigants, is what I mean. Now look at the timeline of before the magistrate court. This was the first time that a complainant went to a higher court. Now, what had happened was a complaint was filed. Mr. Rahul Gandhi was called. Pre-summoning evidence happened. He was summoned. He came to the court. His statement was recorded as well. Thereafter, the complainant himself went to the higher court and got the matter stayed.
Yes.
Because the
Swaty,
judicial officer,
I'm sorry to interrupt you there, but the fact that you're pointing out this procedural irregularity on a television debate, and the Congress party has done that ever since this order has come out, and you've not been able to convince a court of law, what does that tell us? My last point, and then I'll go to Sanju Verma and others.
Yes, that only means that for some, whatever the reasons may be, we've not been able to convince the magistrate courts or the sessions court now, and we will go to the high court. It's not very, it's nothing extraordinary that 2 courts have declined the relief. No. It happens all the time.
Quick point from Sanju Verma, then I'll go to Tausif Ahmed Khan and Amitabh Sinha.
Okay. Anusha, I just want to say, the one thing that I keep hearing repeatedly from the Congress legal eagles is that, 2 years of sentence is very harsh. But I just want to say that the judge has clearly said that 2 years is permissible under law. And under section 389 of the CRPC, the judgment by the judge, whether it should be 6 months or 1 year or 2 years, is completely at the discretion of the respective judge. Yeah. And last but not the least, Rahul Gandhi is not an infant. He is a full-grown adult and he's a repeat offender. He's a habitual offender. As you and me speak, Anusha, there are at least 10 criminal defamation cases pending across the country against Rahul Gandhi for making repeated wild and reckless allegations that Gandhi was killed by RSS, Gauri Lankesh was killed by RSS, Amit Shah was the director of